it's quite difficult to identify exactly how many trusts there are currently in Scotland. The Trust Registration Service had 198,000 trusts and estates registered in the UK, and that was up to the 31st of March 2022. This includes taxable and non-taxable trusts, unless it is an excluded express trust. So using population estimates, that represents one trust for every approximately 339 inhabitants. So on the assumption that the number in Scotland is proportionate and using population estimates for mid-2020, that means there would be approximately 16,123 trusts in Scotland. So that gives us an idea about what we're speaking about today. So now to talk about removal of trustees. So we've looked at removal of trustees in the context of incapacity, but Section 23 of the 1921 Act allows removal on two additional grounds. So those are where the trustee is absent from the UK for a period of at least 6 months or has disappeared for a period of at least 6 months. Now, if sufficient evidence is presented, the court has discretion to remove. That's different from the first two grounds under incapacity where they must remove. And in these two cases that we're speaking about now, the court will obviously look at the evidence presented to them. The bill seeks to improve the position by allowing trustees to be removed without resort to court action in some circumstances. Section 7.1 implements Recommendation 8 in the Report on Trust Law and permits a majority of trustees to remove a trustee where they are incapable, untraceable, convicted of an offence involving dishonesty, sentenced to imprisonment or conviction of an offence, or imprisoned for contempt of court or for not having paid a fine. Now, the paragraphs above do not apply to convictions, sentences, or imprisonments before the section comes into force. And that's really on the principle that a person convicted of an offence should not be subject to a heavier penalty than the one that was applicable at the time the offence was committed.